case briefs, and so much more. LSData's got what you're looking for.
In 1968, the Colorado Supreme Court heard the case of Shutt v. Kaufman's Inc., which centered around the legal principle of res ipsa loquitur. This doctrine suggests that if someone is injured, and it is clear that the defendant had control over what caused the injury, the injured person can claim the defendant was probably negligent. The incident occurred in a shoe store where the plaintiff was hit on the head by a falling shoe stand. While the defendant argued they were not responsible for the accident, the plaintiff claimed that the doctrine of res ipsa loquitur applied. The court needed to determine whether this doctrine was applicable to the case, considering factors such as the store's layout, the conditions of the accident, and the store's responsibility to ensure a safe environment for customers. The jury ultimately ruled in favor of the defendant. The plaintiff then appealed, arguing that the doctrine had been applied incorrectly and that the court should have directed a verdict in their favor regarding liability. The defendant maintained that the doctrine was not applicable in this case. The court ultimately held that the doctrine of res ipsa loquitur did not apply to this case, and the trial court's instructions on the doctrine were improper. However, this did not prejudice the defendant, so the trial court's judgment was affirmed.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.